This is Advisor 3.0, a show designed to help you as a financial advisor elevate your professional practice, transform your clients' lives, and take your business to the next level. I am Abraham Okusaya. Welcome to the show. Death is more universal than life. Everyone dies, but not everyone lives. Andrew Sachs, English actor. When someone dies, the grief of those left behind is often compounded by the practical need to sort out their affairs. My guest today believes that one of the most important gifts you can give to your loved ones is a clear guidance and instruction on what you would like to happen when you're no longer around. In fact, his book is titled Your Last Gift, Getting Your Affairs in Order. And I cannot think of anyone more qualified to write this book. He's a former private client solicitor and tax advisor and a vicar, yes, an ordained minister in the Church of England and a deputy lieutenant of the County of Norfolk. Matthew Hutton, welcome to the show.
You're very kind, Abraham. Thank you so much for the invitation.
It's a pleasure to have you. This is a first in the podcast. We haven't had a clergyman on the podcast before, so maybe we'll get to that. But first, I have to say, for a book on such a morbid subject, this is incredibly well written. I really enjoyed reading this book. My introduction, my quote in the intro was obviously from the book. This is one of the things I love about the book. These little quotes that you have, all over the book. It's so easy to read. Read it in one sitting. Made so many notes. So before we dive into the book, tell us a little bit about yourself, your career. How do you go from private client solicitor to where you are today?
Well, Abraham, let's start at the beginning. Not quite at the beginning, but I was brought up in Norfolk on the family farm, and I went away to school and to university. And then when I left Oxford, I decided to become a solicitor. So I trained at one of the big London firms, and I did a variety of subjects, including corporate tax, private client tax. I always knew that I was going to come back to the farm, so I ended up specializing in private client tax, tax and trusts. And then I had a brief spell with Rowan Pitman, which became Warburgs in Big Bang in the mid-80s. And then in the late 80s, 1987, I found my way to two merged firms of solicitors in Norwich. I joined them. Things didn't work out exactly as planned. So after a couple of years, I left and started off on my own, not as a solicitor, but as a member of the Chartered Institute of Taxation. So what I was doing essentially was advising firms of lawyers, firms of accountants, in the same way as they would take their clients' questions to barristers, to specialist counsel. And I did that from 1989 through to 2013. So that was the tax part of things. Meanwhile, I was running the family farm. And then in 2010, I was packed off to theological college by my dear wife, Annie, because what she didn't want me saying on my deathbed was, I wish I'd studied theology. And so I was there at a college, training college in London as an independent student. And then while I was there, I sensed a call to ordination. So I got ordained in 2014. So for the last 10 years or so, I've been what's called a self-supporting priest and doing whatever's required of me. So that really explains where I've got to today.
And again, before we go into the book, being a priest gives you a different dimension of this, of course, because of death and people going through bereavement. Because, of course, you have to support people through what may be one of the most difficult and challenging periods of their lives.
Yeah. No, I mean that's true. And it's an enormous privilege. Especially, of course, they're people you know. If they are friends, they may be people you don't know, but either way, you're there to support them, and you might be there in the final stages of life. You might be with them as they die. You'll be with the family as they plan the funeral, and then afterwards. So you're there for them, and you take your cue from them. You take your cue, obviously, from God, what you think He wants you to say, but equally, you just want to be there with them, maybe saying nothing, maybe saying something, maybe with permission holding hands, whatever it is. You're there, and it's the most extraordinarily intimate experience, I think, that you can possibly imagine. And as I say, it's a huge privilege.
So let's talk about the book, Your Last Gift. So give us a little bit of a background, to why you actually wrote the book.
Yeah. Well, it all goes back to the autumn of 2019. And my wife and I had some friends to stay. And among them were two recently widowed women. And one of them in particular, her husband, had been a solicitor, very fit, one of the fittest people I knew, who had died very unexpectedly abroad, and would you believe it, without a will. And she was left in a terrible state for a very long time. And then the other one, whose husband had been a great friend of mine, he had had dementia, tragically. There was a sense in which we could foresee what was going to happen. But they were both staying with us, and we were talking, obviously, as a group of friends together. We were supporting them, talking to them. And together they said, Matthew, knowing that I had been an author, I'd written lots of books on tax. You wouldn't want to read those, Abraham. But they said, if you were to write something to help people who suddenly find themselves having to cope with these enormous stresses, it would be a real gift. So it was that phrase, Your Last Gift, that prompted the title of the book. And I mean, I'm a late developer. I take time doing things. So it took quite a few years for the thing to take shape in my mind. And then eventually I published it in December 2022. And then, as you know, had just brought out another edition. So that's how it came into being.
So we'll come back to the to the subject of will in a sec, but why is it that this subject of death and what happens after one dies is such a difficult subject to talk about? Why? I mean, it's almost I would say almost certain. It is certain for everyone. It is going to happen, and that's the point you make in the book. But why are we so engrossed with life and living that we don't want to talk about what happens when we're gone?
Yeah, I mean, Abraham, I suspect your answer is probably as good as mine here. But there is this focus, isn't there, on living life to the full, insofar as you can. And of course, you have to say that we in England at the moment, or most of us, or many of us in England at the moment, are hugely privileged compared with many people around the world, if we have the ability, more or less, to live as we want to. But death has a sort of finality about it. I think possibly there's been a decline in religious faith, which may have something to do with it. If you go back to Victorian times, of course, it was very different. But nonetheless, it's extraordinary if you think how good we are at making plans for the future. We make plans for who we'll live with, perhaps who we'll marry, where we'll work, where we'll live. If we have children, how to bring them up, where to go on holiday, what to do by way of pastimes. So all things, if you like, that are contingent, things that we enjoy doing. But the one thing, the inevitable, as you say, the ultimate statistic, 1 in 1 dies, we don't plan for. And one of the points I make in the book, which I think is very, very important, is because I meet people and they say, "What's your book about?" And if I'm feeling naughty, I say it's about death, and that immediately stifles the conversation. But actually, if I'm feeling a bit more imaginative, I say, no, it's a book about life. It's a book about life, because I think the way that you live your life, and you will know that if there's been a friend or a member of the family who has lived a full life, lived to a ripe old age, and then whether it's a religious service or not at the end, there's a celebration, there's a sense of thanksgiving. So I think in the same way as we celebrate birth, then except, of course, in very dire circumstances, and of course there are those awful circumstances, but in the ordinary course, many times we need to celebrate and give thanks to death, for death. Give thanks for the life, for the person who's been taken from us. And of course, their memory will live on in a whole host of ways. And so what happens, and I don't know whether it's happened to you, but to people when there's somebody close to them for the first time and they die, and they're consumed by grief, not unnaturally, but of course, then they discover, quite to their surprise, quite how much stuff, whether with officialdom or anyone else, there is to be done. So the whole point of the book, as you'll have gathered, was to make that process of dealing with what I call the stuff much easier, set up in advance, discussed in advance with the person who's gone.
And a lot of people listening, a lot of our listeners are, financial advisors, people who work in financial services. And so they'll be familiar with this as I am. But, and the thing that it's easy to jump to is to say, well, we need to get people to have a will. I was quite surprised at the amount of stuff that you have to think about and deal with. You have checklists in this book. In fact, you divide this up into 2 checklists. The immediate ones and the ones that you should, the second checklist that you should deal with more slowly. Talk about that a little bit. This idea of having a checklist and of what should be on this checklist of things that you should think about to ensure that the people you leave behind are in the best possible situation.
Well, it's interesting you should say that, because in writing the book, I enrolled the services of what I call 5 critical friends. And they were people who knew me well and knew the subject to an extent. And so they reviewed a draft of the book and made helpful suggestions. And one of them, who in fact happens to be my retired solicitor, had the idea of these 2 checklists. One would be the critical checklist. That's the absolute essential one. And the other would be what I call the comprehensive checklist, which has 22 points in it. And I suppose the point about both checklists is that they ensure that you haven't forgotten anything. So just running very briefly, don't worry, I won't do the comprehensive one, but the critical one, lasting powers of attorney, absolutely essential. That if you're unfortunate enough to lose mental capacity, then for property and financial affairs, health and welfare, you need to appoint somebody close to you to trust to make those decisions. Particularly, of course, if you're in dire straits in hospital, there needs to be somebody that the medics will look to. Who are the first people to tell about the death? What about appointing guardians for minor children? What about pets? Access to cash, absolutely critical, because if the one who dies is the high earner or the breadwinner, then until you get probate, which is the authority of the court for the executors or those looking after the affairs of the deceased, are in place, and it's taking a long time now, it could take up to a year, then everything gets frozen. Passwords, digital assets, absolutely crucial. What happens if they can't access your digital assets? Will, where is my will and letter of wishes? Will come onto the will, and registering the death, which has to be done within 5 days. Where's all the information? So that's a brief review of what I call the critical checklist, things to think about. And then there are many more things going on from that. So what, and you'll know, having read the book, and thank you so much for your generous comments about it, that at the back of the book, these checklists give a reference to the page number of the book with which they deal. So that's really the importance of the checklists.
You mentioned lasting power of attorney there. This can be quite complex and time consuming. How would you say that people should go about this? Is this something that, even from a professional financial advisor's point of view, would you just hand this over to a client, to go and get these forms and complete and maybe guide them through it? Or would you say this is something that needs a solicitor to help with?
Well, I suppose I might be accused, being a retired solicitor, of saying, of course, you must go through a solicitor. Actually, you can do it yourself. You can get the forms off the internet, fill it in yourself, file them, pay the fee, which is £82 per attorney, and then they get registered, and then you file them away in a drawer and hope, of course, they'll never be needed. But I think it's probably a good idea to go to your solicitor to get them done. Yes, it'll cost you a bit in the way of fees. Solicitors, like financial advisors, have to eat after all. But they are among what I call the 3 essentials. My 3 essentials are lasting powers of attorney, second wills, and third funeral arrangements. You set out what you'd like to happen when the time comes. And I think certainly with wills, whether or not there's any inheritance tax planning to be done, and of course we can talk happily about inheritance tax, yes. Possibly with an election coming on the 4th of July, but I think it's, it is extraordinary. Sorry, I'm anticipating the next question, wills. It is extraordinary that only 44%, nearly 3 in 5 people in the UK don't have a will. So I really think that and again, you can do your own will if you want. I certainly wouldn't advise it. You can download something off the internet, but I think it's terribly important that you have a solicitor, that the people that you deal with, financial advisors, and I meet financial advisors, you'll be glad to hear, and I'm constantly struck by the closeness of the relationship they have with their clients. And I think similarly, you need to find somebody, and it might be on the recommendation of your financial advisor or somebody else, that you have a solicitor you trust implicitly, who will give you the right advice. If they can't advise you, they'll say so, or they'll refer you to one of their colleagues. But you go to that solicitor to make your lasting powers of attorney, to make your will, and deal with anything else that needs to be done.
So let's talk about wills then. You alluded to the point, only about 46% of people in the country have a will. Someone might ask, why? Why should you make one of these things?
Well, I think the short answer is, what happens if you don't? And this is assuming that you've got any sort of property to leave behind. But you don't have to be staggeringly rich. You just have to own something. And the question is, what happens to it and who deals with it? And if you don't have a will, then there are what's called the intestacy rules. And intestacy is the situation of dying without a will. And what the rules say is that if there is a surviving spouse or civil partner, and just pausing in square brackets there, you or your clients or people listening to this need to be terribly careful of the situation where you live with somebody, and you may have lived with them for years. You may have a terribly stable relationship, but you're neither married nor in a civil partnership. They're what used to be called rather colloquially as a common law wife or husband, and they have no entitlement under the law, either no protection from inheritance tax and so on. So let's suppose you die, you've got a spouse or a civil partner surviving. They get your personal chattels, which is your personal possessions. They get what's called a statutory legacy of £322,000, and then they get half the balance. And the other half of the balance goes to children at age 18. So you could have the situation where you're quite wealthy. I mean, if let's say there's a married couple or couple in a civil partnership, you've got a total of £1 million between them if they own their own house that is taxed at 0%. Above that, subject to reliefs for farming and business property, there's a flat rate of 40%, can be reduced in the case of charitable bequests, but 40%. So not only might you find yourself in the situation of having to pay inheritance tax on the first death, not being able to defer it to the second because half goes to the children, but not only that, it might be entirely the wrong thing for children to inherit at age 18 because they might have gone off the rails. They might have got, to bad company, bad influences. And really what needs to happen to anything they get is that it needs to be held in trust so they can be looked after financially. And then supposing there is no spouse or civil partner, but there are children, everything goes to the children at age 18. If there aren't children, then it goes to parents, grandparents, brothers, sisters, nephews, nieces, so on. In other words, there's a chain of priority, so to speak. And the other situation in which that chain of priority operates is in terms of who looks after everything. They're not called executors, they're called administrators. And so you may have somebody wholly inappropriate looking after your affairs. And the great thing about making a will and choosing executors and talking to the people that you've chosen is, of course, that they have a very clear idea, not only of what you own, but of what you want to happen. So I'm afraid it's, it's what's called the bleeding obvious, really, that everybody needs a will and everybody needs to think carefully about the choice of executors.
And the other part of this is guardians for minor children. It's essential, as you say. One of the other things in the book was this idea that it's not just about the will, but also, the letters of wishes, as you call them. Talk a little bit about that.
I mean, letters of wishes come in only where there's a sort of discretion to be exercised. So, for example, if under my will, I'm not telling you what's in my will, but supposing in my will I left X £1,000 to charity, Y thousand. Abraham. Oh, I thought you were saying me. Y £1,000 to my children, and the balance to my wife, there wouldn't be any need for letters of wishes. But if, for example, I left that X £1,000 among such charities as my executors shall choose. And then I might leave a letter of wishes and say, well, actually, at the moment, these are the charities that I'm really keen on. In 5 years' time, there might be a different list of charities. So in other words, you don't necessarily have to name the charities in the will. You define them by reference to a class. And I have to say, interestingly, there's been a really good exchange of views on LinkedIn recently about this. And, I don't want to be rude about charities at all, because they do up and down the country a fantastic job. But sadly, it is known that some charities are quite grasping, because if they are left not so much a particular sum of money, but a share in residue, then they or their solicitors will be on to the executors and their solicitors and saying, look, where's our money? And of course, their excuse will be, which is quite a good legal excuse, is, well, we owe it to our beneficiaries. And you can't really dispute that. So I'm now saying more and more, yes, if you're talking about relatively small amounts, then that's fine. But if you're talking about much bigger amounts, I think it's far better not to mention them on the face of the will so they don't know, and then leave it to the executors to determine in accordance with the letter of wishes. And then letters of wishes might come in the different case where, for example, you die with minor children, tragically. And not that you necessarily think they're going to go off the rails, but you say, look, it's wholly inappropriate for them to come into such big sums of money at age 18. Let's give a letter of wishes to, which I'll talk about, to my executors, to say, look, other things being equal, you can drip a bit of income to them. You can pay university fees, for example. You might help them put down a deposit on a house or a flat at age 25. If everything goes well, let them have it at age 30. But if not, then hang on to it. And so it's those sorts of situations where the thing about the letter of wishes is, of course, that it's an informal document. It's not a legal document. I think executors have to be quite brave to disregard it because, of course, you've signed it. But it's very helpful to executors in terms of helping them carry out their duties.
So, one of the other ideas you talked about in the book was about using a will and some sort of discretionary trust as a way of protecting the identity of the beneficiaries?
Yes, that was the idea, that you don't necessarily want to mention, you may not want to mention on the will, on the face of the will, who the particular individuals are. And so you could define them by reference to a class. You could say my children, you could say my godchildren, you could say nephews and nieces, whoever they are. By contrast, certainly in my case, I can come clean about this. I do mention my children and my grandchildren on the face of the will. But if you don't, for whatever reason, then the great thing about a discretionary trust, which needn't be as frightening as it sounds, a discretionary trust can last only 2 years, because there's a great rule for inheritance tax purposes that if appointments are made or gifts are made or gifts are varied within 2 years after the death, then effectively they're written back into the will for inheritance tax purposes. Alternatively, you might have the trust going for 80 years or less than 80 years. It doesn't matter. I think trusts are much misunderstood. Sadly, too many trusts are too restrictively drawn. But I think if you have a widely drawn trust, very clear letter of wishes, then they can play a very important part in family financial planning.
And since I have you here, I'm going to maximize that opportunity. Um, um, Business assets. Um, you talked about business assets in the book, and indeed about how the shareholders agreement or partnership agreement uh, can actually take precedence over the will, what's expressed in the will. I want you to talk a little bit about that, and then I have a follow-on question.
Well, Abraham, the first thing I must say, of course, and you'll appreciate this, is I'm not giving you advice.
I understand that.
But both agricultural property relief for farmers, and there's been a lot of speculation about that recently, pending the outcome of the general election, and business property relief, which is the much more generous relief, both at 100% for business assets. Very important to take advantage of those. And of course, there are three types of business. There's a sole trader, who might be the person carrying on the corner shop, for example. There might be a limited company, which carries on a trade. And we're talking about trading businesses, not investment businesses. Or there might be a partnership, which carries on a particular business. And typically a partnership will be, there will be a partnership agreement, which will set out the way in which they carry on business between them. They have meetings, they share income, they share capital profits, and so on. And it will also provide what happens on the death of one of the partners. And that's where you get what are called preemption rights. In other words, typically the partnership agreement will give a right of preemption, a right of buyout to one of the partners. It might be a son, it might be a daughter, it might be somebody else, to exercise that right and buy out at fair market value. That will have to be determined, the estate of the person who's died. And the point that I'm making in the book is you have to you have to construct the provisions of the will alongside what's said in the partnership agreement. And it may well be that the partnership agreement takes priority.
Yes, and presumably this will be done in a way that doesn't create a situation where the IHT exemption, the IHT exemption on the business is lost in the transfer. So in other words, the sale, the preemption can't take place until the assets actually passed on to the to the beneficiaries.
That's right. It's very important. And of course, these provisions will be drafted in such a way as maximizes the availability of relief. So there's no way, for example, that it could be said that at the moment of death, the assets are subject to a binding contract for sale. That's the kiss of death. That's what mustn't happen.
Yes.
So at the moment of death, the deceased is free to dispose of his or her assets as they want. And then you simply read into the partnership agreement after that to find out what happens. That's right.
Again, I have to say, my listeners might be thinking, "Oh, we're going down the rabbit hole here." I do that deliberately because they're financial advisors and financial professionals, and they understand, these things. But the book itself is so written with such a, care and simplicity that it doesn't, and you signpost people to seek professional advice for these things. So, I guess to try and wrap this up, why do you think that this is such a good book for advisors to consider? Giving, I would say, not just recommend, give copies of these books to this book to their clients.
Well, here is the book, as you say, and indeed there is a firm to whom I've lectured with their clients who has taken it upon themselves to give copies to their clients. There's another book which is what's called the checklists and forms, because what where the book is taking you to is this series of checklists and forms on the website, which typically
Yes.
you will download, you will make your own. Some of them won't be relevant to you, others will. You can expand or reduce boxes, all that sort of thing. And then, of course, you will leave those and regularly review them in a secure place. There may be people, probably quite like me, who are not terribly technologically happy, that might prefer to do things in hard copy. So if they do, then we produce that available at extra cost. But I think the reason why, sounds as though I'm blowing my own trumpet, and sort of forgive me, doesn't come naturally. But and there are other books on the market. I don't think there's anything quite like this. But what I set out to do, because it's no more than about 120 pages, as you say, I wanted to keep it quite light. There are cartoons, there are things that make you laugh, there are quotations, there are anecdotes, there are stories from my own family history. And it's something that financial advisors and indeed other professionals, solicitors and accountants, private bankers, might like to suggest their clients buy, or if they're feeling generous, give it to their clients, simply because it's part of the service. In other words, as I understand it, what a financial advisor, what a really good financial advisor is there to do, it is not just to say, buy this share, sell that share, invest in this bit of land, or whatever, or take out this bit of life assurance. But they're there, looking at the whole picture. There's somebody that the client absolutely trusts. And so what they're doing with this book is saying, well, this is a way in which you can take your family with you, so to speak, or on the journey. You can talk to them about it, that when you do eventually close your eyes, hopefully at a ripe old age, you can rest content that you have done all you possibly can be to leave not just your financial affairs, but everything in apple pie order, which is going to make it so much easier for those who follow on after you.
I couldn't agree more that this is just such a powerful resource to give, or resources including the checklist to give to clients, and financial advisors are well placed, if not more than any other professional, better placed than any other professional, to actually have this conversation with their clients. You mentioned the website. Sorry, you mentioned there is a website there. Do you mind me asking just to confirm what the site is?
So it's called www, and then all one word, yourlastgiftbook.com. So yourlastgiftbook.com. And what it does is describe the background to the book, describe the book, tells you where you get the hardback, either from Amazon or from a variety of local bookshops, which are increasing all the time. We're putting those on the website. Or you can get the e-version. Most recently, I've done an audiobook. So I've read the audiobook, which you can get from a number of platforms. And there's also, very significantly, an updates tab. And so, for example, I mentioned that in case of intestacy, there was a statutory legacy of 322,000. Last year, that was updated. So I put that on it. If there are any immediate immediate. There's a probate fee that's just gone up, so that's there. The other thing, very significantly, obviously anybody buying the book now will buy the second edition, but people who've got the first edition might think, well, hang on, do I need to get the second? And yes, I'd always like them to get the second because I get a bit more. But what I've done is I've put 10 to 12 pages of text under the updates so they can go there and find out what other material has been added. So I want to use the updates tab in a very sort of proactive sort of way.
Fantastic stuff. On a lighter mood, one of the one of the things I found interesting in the book was that what you do with your memorabilia, badges of honor, for instance. So you mentioned in the book that things like your badges for the OBE or CBE might not have to be returned, but maybe some other memorabilia has to be returned, like the one I'm going for, your knighthood or whatever. Is that true, or am I making that up?
Well, you've always got to tell the authorities at St. James's Palace, obviously, about the death. Some things, as you say, the MBE can be kept by the family. It simply says, and I'm reading here, some insignia of the greater orders are returnable on death. So, Abraham, I would have thought that with you, the sky is the limit.
Yes, I take that as a future knight of the realm. It's been such a wonderful conversation, Matthew. Thank you for your time. Thank you for your wisdom. And thank you for writing the book. And as we started this podcast with a quote from your book, I am going to end with another one, which is, when you've told someone that you've left them a legacy, the only decent thing to do is to die at once. That's from Samuel Butler. Matthew Hutton, thank you for your time. Thank you for your wisdom. Thank you for coming on the show.
Abraham, thank you so much. It's been a delight.
That's a wrap on today's show. Massive thanks to my production crew, especially Jake Osha, Melissa Canham, and the entire team. And of course, to our sponsor, Timeline, the market-leading provider of integrated planning technology and model portfolio service to advisors. I do hope you've enjoyed today's show. Head over to Apple Podcast and give us your review there. Until next time, goodbye.